Hi everyone, welcome to the last session today, contracting in the cloud. Brendon Noney is my name, I'm the partner of the firm, and we have Emily Lucas here, is one of our bright young lawyers in our commercial and corporate team. I know this is the last session on a Friday afternoon, so I hope everyone's still remaining awake.
Sorry to jump in, I just wanted to mention that there is actually one more session.
The weekend just yet. Contracting in the cloud, it's an area where I take a bit of a keen interest in, having done this for a while. It's an area where cloud computing, something's changing all the time. It's a forever moving feast in a sense. This presentation is given from a B2B perspective rather than a B2C perspective, so you should keep that in mind when we're going through the slides. And of course, at the end, there's time to ask questions. Now, just in summary, the reality is cloud computing, cloud contracts are merely just another form of outsourcing, albeit that it's a specialised form of outsourcing. So I'll hand over to Emily to take us through the first part of the CLE, and then I will bump in a little bit later.
Great, thanks Brendon. Okay, so simply put, cloud contracting is the delivery of computing services over the internet. The features are that it's hosted externally, it's accessed via the internet, it's a relatively standard product, it's immediately scalable, customers receive automatic updates, and the costs vary according to how much or little is utilised. This is contrasted against on-premises software systems, in which it's usually hosted on the organisation's own systems. It's accessed via their own network. It's a relatively tailored product. It's limited by its own capacity. Updates require implementation, and it's a fixed cost. Almost everyone here today has interacted with some form or another with cloud software, I'm sure. This might include secure service for cross devices such as Apple iCloud and Google Drive, streaming services such as Spotify and Netflix, customer relationship management platforms such as Salesforce, productivity platforms such as Office 365, business travel such as Concur, and electronic signature and transaction management such as DocuSign. So there are many advantages of cloud software. Cloud-based software reduces the upfront costs of capital expenditure of computer equipment and related expenses such as physical data centre and support staff. It reduces the associated financial risk to the organisation by replacing upfront costs with reasonably predictable operational expenditure, and you only pay for the amount of computing processing and data storage that is actually used by the customer. It reduces ongoing costs by using infrastructure and technical specialists shared among multiple customers to achieve economies of scale. Cloud-based software's infrastructure can also rapidly and flexibly scale to meet peaks and troughs in usage demand. Another advantage of cloud-based software is that customers have access to upgraded hardware and software. This is important because as technology grows older, the competitive advantage eventually diminishes to a point where it becomes a competitive necessity. Everyone has it and needs it and uses it. For those that continue to use older technology past its useful life, technology becomes a competitive disadvantage. Cloud-based software also improves business continuity and the availability of computing infrastructure if users have guaranteed available network connectivity. The computing infrastructure is typically located in multiple physical locations for improved disaster recovery. Last but not least is my favourite advantage, and it's the potential benefits on the environment. Cloud-based software has the ability to reduce carbon footprint due to the more efficient use of computer hardware, requiring less electricity and air conditioning. There are three main generic models for cloud services, the first being infrastructure as a service. This provides highly scalable and automated compute resources and networking, allowing consumers to purchase resources on demand as needed. There is no requirement for outright hardware or network equipment purchase, and the consumer is responsible for the operating system and setup. The second is platform as a service, which provides a framework for developers to build applications. The runtime and downtime are provided and managed by a third party, with management of the application provided by the consumer. Last but not least is software as a service, which is the most commonly utilised service. It uses the internet to deliver applications managed by a third party vendor to its users. Responsibility for the application stack is with the third party vendor. All three models are essentially utility computing, where you are generally billed for what you use, making it a potentially more cost-effective approach to procuring and consuming computing services. Like with any other technology product, there are always new models coming online, pardon the pun. Some evolving software solutions include container as a service and function as a service. There is also a distinction between private and public clouds. So public clouds involve resource pooling, where vendors use shared computing resources to provide cloud services to multiple consumers. Virtualization and multi-tenancy mechanisms are typically used to both segregate and protect each customer and their data from other customers, and to make it appear to customers that they are the only user of the shared computer or software application. This is contrasted against private clouds, where customers may refer to on-premises network solutions, walled off section of the public cloud, or a third-party hosted private servers with or without management services. It allows service suppliers to design solutions that deliver the benefits of cloud computing. It also keeps key IT infrastructure within the customer's physical or virtual control, or at least within a specified geographical location. There are also hybrid options where data and applications can move between private and public clouds, for example, depending on the sensitivity or volume, or a private cloud shared with only a select few organisations. So now that I've run briefly through the many advantages of cloud software, we're going to take a closer look at the key risks that are involved with cloud computing. A cloud user who transfers physical control to the data to a third party will necessarily reduce their control over that data. This presents several risks, such as data being lost or corrupted, interruptions in services, unauthorized or improper access or use of the data, and possible retention of data by the service provider. It might be trite to say that there are companies that know that they have been hacked and companies that have been hacked but don't yet know it, but it's also not far from the truth. The Experian case study demonstrates how moving to a cloud-based system can present a risk of unauthorized access to a data stored in the cloud. One of the largest data breaches in history indirectly involved Experian, one of the three main credit reporting agencies in the US. Experian acquired a company called Court Ventures, which gathers and aggregates information from public records, in March 2012. At the time of the acquisition, the contract enabled customers of US InfoSearch to access the company's data to find individuals' addresses that would help them determine which court records to review. Court Ventures sold information to a number of third parties, including a Vietnamese fraudster service, which then provided its own customers with the opportunity to look up personal information of Americans, including financial information and social security numbers, which was then used for identity theft in many cases. As Experian claims, after Experian's acquisition of Court Ventures, the US Secret Service notified us that Court Ventures had been and was continuing to resell data from US InfoSearch databases to a third party, possibly engaged in illegal activity. The suspect in this case posed as a legitimate business owner and obtained access to US InfoSearch data through Court Ventures prior to the time Experian had acquired the company. Experian maintains that no Experian databases were breached. US InfoSearch's database were the sources of the consumer information. Some news sources cite that 200 million records were breached in this incident, which continued for more than 10 months after Experian had acquired US Court Ventures. Although databreaches.net reports that 200 million is the figure representing the total number of records stored in the database that was breached. The actual number of records exposed, according to Experian, is unknown, but believed to be much lower. So another key risk is the availability and performance of cloud-based software. The service level agreement is the document that will define system availability. The service level agreement should specify when scheduled outages should occur, the duration of said scheduled outages, how the scheduled outage is intended to affect the guaranteed performance of the system availability, whether or not there is a procedure for compensation for breach of the SLA or contract. And finally, it should also specify the nature of redundancy mechanisms and off-site backup to prevent data corruption and loss. Access to data and IP in cloud software is another key risk. Cloud providers with servers spread across multiple geographic areas may offer more robust systems and reduce risk of data and loss and downtime on the one hand, but privacy and jurisdictional issues may arise. There are laws in some countries, including China and the US, which equip the government and other agencies with power to access information, including data belonging to other companies. US courts have also held that a company with a presence in the US is obliged to respond to a valid demand for information from the US government, regardless of the location of that information. The government may demand access to information stored in an external location, provided the company retain possession, custody, or control of the data. Another key risk that is often overlooked when engaging in cloud computing services is the portability and integration of your data. A significant issue that must be considered by cloud users relates to data exit and the notion of being locked into certain applications or systems. Any organisation considering a move to the cloud should be aware that they may have to change providers in the future. Accordingly, portability and interoperability should be considered by potential cloud customers from the outset. There may be circumstances that necessitate a switch of cloud providers, such as an unacceptable increase in the cost at the time of a contract renewal, a decrease in the service quality, or the service provider ceasing business operation for whatever reason. In these circumstances, the relevant considerations will depend on the type of cloud service provided. The main considerations will either be preserving the security functionality, minimising the amount of application rewriting, or the portability and applications and successful data migration. Given the lack of interoperability standards, transitioning between providers may be a difficult process. Data retrieval is also a significant issue for cloud computing, as data backup may require use of certain applications which originally created the data to be available in order to access it. This can present a serious issue in the cloud setting where rebuilding an application to read data may be impossible. Given the data retention is often required by law for certain organisations, these issues must be comprehended from the outset of any cloud relationship and appropriately addressed in the relevant service contract. Organisations should consider interaction with termination provisions. So, for example, what if the agreement is terminated unexpectedly, or the provider goes insolvent and the data can no longer be accessed or is deleted by the provider? What if the organisation is contracting with a vendor, but the vendor subcontracts part of its services to a third party, and the vendor of that organisation ceases to exist for whatever reason? Organisations need to know exactly who they need to contact in order to retrieve this data should this circumstance arise. Organisations should also be aware of vendor lock-in. Making use of cloud vendors' native services can lead to cost savings and acceleration in building a solution on the one hand. However, this could lead to a complete reliance on those vendor-specific services. This could cause an issue if the service is terminated and you have to migrate to another service. You will find that the velocity of change on the cloud is quite high, and service churn can be quite high as well. Vendor lock-in can also cause an issue if cloud vendors' costs increase unexpectedly, and can apply budget pressures or nullifies the service's return on investment. Organisations should also ensure that at least your data is accessible in the event you need to exit a service and move to another offering. The last key risk I wanted to flag was liability. Most IT service providers offer their service on an as-is basis without assuming any risk or liability to the extent it is permitted by law. This presents a significant risk to cloud users when they cease to control their data, and where small to medium-sized enterprises will have little to no negotiating power to alter the terms and conditions. Many cloud computing providers offer no warranties regarding the protection from external attacks. Even where the security of data is physically beyond the control of the customer, the provision of data security is still left within the hands of the customer. As cloud computing is an internet-based service, there will always be risks with unscheduled system outages to end users. A business with an in-house system can make alternative arrangement when outages, maintenance, or upgrades are scheduled. However, when a business operates completely from the cloud, the internet server may shut down without prior warning, and all critical applications and data could be lost for the duration of the outage. It is therefore important to ensure that these issues are properly dealt with in the applicable service contract. Just as a local office system will require data backup and maintenance and security checks, so does a server stored on offsite. Cloud computing companies will generally back up data by means of another offsite server. However, as with local IT infrastructure of any business, these systems can experience unavoidable failures. End users should be sceptical when a service provider promises complete protection, as this is unlikely to be a reality. When a business experiences a systems glitch, immediate technical support will often be required to assist the business in understanding and rectifying the problem. An issue with cloud computing is that end users are often unable to do anything during the systems glitch and can only wait on the functionality of the systems to be restored. While direct technical support may be available for an additional fee, this support is likely to be inadequate when multiple end users experience problems, as support lines may become overwhelmed and congested. Again, these issues should be addressed from the outset in the service contract, and the basis for any compensation should be agreed upon upfront between the parties. So I'll now hand over to Brendon, who will walk you through some of the key contractual issues that you can expect to see in cloud service agreements, together with what you should be requesting when you're negotiating these agreements.
Thanks, Em. Yeah, look, broadly, a lot of those topics that Emily has just covered in a broad sense is what we will have a look at in terms of the contract itself, and you'll see when we go through the slides. We've got two columns there: what to expect when you're presented with a contract from a cloud provider, and then what to perhaps look at negotiating or request back the other way. You know, things like, just pick up on that last point that Emily made about disaster recovery. You know, usually there is another off-site disaster recovery centre, but one of the things that is important, of course, for any business, is how quickly can you get back up and running, and how quickly you might be able to do that will depend very heavily on technical things like, well, how big is the pipeline from the disaster recovery centre back to base, time-wise, how long it's going to take to get that data restored, so on and so forth. So there is a lot of granular detail in these cloud contracts that not just lawyers that look after them, the contract, have to look at, but they should be working very closely with their technical teams, the business, and also, for example, their CIOs and the like. Look, in the early days of cloud contracting, quite a while ago now, it was kind of the providers sort of took a all care, no responsibility approach, but as time has gone by, with things like privacy and data security becoming more relevant, regulations more stringent, you'll find that the providers are very keen to ensure that the contract that you enter into with them suits you as a business. Similarly, as a business, you need to make sure your compliance issues are correct, and that you are compliant with, for example, if you're a financial services industry, if you've got APRA prudential standards that you have to comply with, that they are in fact complied with. We'll get to due diligence a bit later when you're deciding to either shift into the cloud, or quite frankly, if you're already in the cloud, what you should be doing to constantly monitor what's going on with your data. And Em will take you through that later on. But as to how one of these contracts look like, if you haven't seen one before, it's usually in the form of a master services agreement, or a general terms conditions, if you want to put it that way. And then off the back of that, you'll have a number of schedules that will contain in each schedule the services that are being offered to you. Those services will be specified as to costs, as to specifications, so on and so forth. And albeit that they are schedules, they are things that your technical team should look at and give you as the lawyer advice on what should be negotiated in those schedules. You'll also have an acceptable user policy that will be tucked in the back as a schedule, and there will also be some service level agreements, which we'll come to in a minute. And it's really those service level agreements. The devil, if you like, of these arrangements are buried in those service level agreements. So you can make sure that those agreements are suitable to your business, and we'll run through that in a minute. But some of the headline or big ticket items are data security, things like privacy compliance, flexibility of the services, scaling up, scaling down, and the licensing arrangements around that, and the costs and the fees. Disaster recovery, we've already mentioned, and business continuity, warranties that are offered, including limitations of liability, and jurisdiction, of course, is another one. Where is your data sitting? Is it here in Australia? Is it offshore somewhere? Are you going to be limited to actions you can take because, for example, the contract specifies a particular jurisdiction? They're all very, very important things. And as I said at the outset, these are really things that are looked at on a B2B basis. In this CLE, you just have to take a look at your Apple terms and conditions. I'm not sure if anyone really does look at their Apple terms and conditions, but you'll see that there's a remarkable difference between those terms and these terms that are generally offered to business. So if you have a look at here, modifications and IP, you can see on the left-hand side, that's probably what will be served up to you from the provider, and then down the right-hand side, what you should look at negotiating. One of the critical things about modifications and IP is, well, if you have to at some point in the future take your data or your software that you're using as a service and transfer it over, it might be customized software, transfer it to another provider for whatever reason, cost, services, etc., that you can actually take those modifications that have been made to your data and software with you. It's otherwise you don't want to be putting it into another data center and finding that what you've got there is completely useless to you and the business. Critical matter to take into account. And with that, hand in hand comes, when we're talking about changes to software, quite often cloud contracts will specify that any changes made might be an additional cost or extra cost, almost treated like if you're thinking about building contracts and building a house as variations to the works. Some businesses also may cope very fine with changes, but if you're not told that changes are going to be made to the system and you've got some customized software that's operating there or some data, those changes may affect how you might be able to use that data or use that software. So it's important to get notice of changes that will be made to the software or data or other service that's provided. And if you need an opportunity to test before you go live with that software or modification of the software, then you should have that opportunity and look at making sure that your contract allows you to ask for that. Okay, volume pricing. So I've talked a little bit about scalability, so has Emily. That's one of the biggest attractions of cloud solutions. It means that you're not having heavy CapEx expenses up front, you're not having equipment sit on your balance sheet, and you're paying for a service for the various items that you are buying from your provider. But with that, pricing is a very important element. And looking at things like volume limits and premises limits and like are going to be something that will be in need of close inspection. You can see down the right-hand side there, we talk about having sufficient margin, the volumes, to allow for anticipated expansion and usage in the near term. As we were saying, scalability, businesses might take on a project, you might have to bring in a number of people to work on that project. You're going to have to give them seats to work at, be it at home, as many people are these days with COVID, or in an office somewhere. Nevertheless, you're going to have to have the availability of those licenses to use. So when negotiating, make sure you've got some wriggle room You're comfortable with that wriggle room so that if you do need to scale up, you can. If you do need to scale down, you can. Classic example, a division of a business might be sold off and you have no use for additional licensing or services that have been provided by a cloud operator. So have some terms in there that will allow you to either have that flexibility up front or have an ability to renegotiate those volumes at a later point in time. And that's all because scalability is one of the beauties of cloud services. Okay, data security, privacy. Emily talked about the Experian example earlier, and we all hear from time to time, and almost daily sometimes, about breaches, data. Early on, when cloud computing services came along, I was at a seminar not too different to this, and the person presenting it gave a very rudimentary example of what it might be like in terms of data security, and he used the example of taking a filing cabinet full of your data, sticking it in the middle of Pitt Street, and letting anyone and everyone walk by it. And the reality is that that's what cloud services are. You have your data flowing backwards and forwards across the internet into your cloud provider and out of your cloud provider, and who knows where around the world. So it's akin to doing that. Of course, data security, particularly when we've got regulations in Australia like and laws like the Privacy Act and the Australian Privacy Principles, and the consequential problems that come with breaching those things, including hefty fines, including having to have plans in place around notification for data breaches to the Privacy Commissioner if needed. And also in terms of having a consequent reputational problem because the organisation whose data is now out there in the public has somehow not taken good care of that data is a very, very large risk. Hence, you might see in a cloud contract, depending on where the provider is based, you might be served up with only GDPR regime applying rather than Australian privacy principles. So make sure that fits. It's like any contract. It's got to be tailored for your particular business or needs for it to work properly. And the thing about that is that if it doesn't fit properly, it allows wriggle room, and then as the customer, you might end up in a very poor predicament. And as I said at the outset, cloud providers are more than happy to negotiate, in my experience, reasonable requests for changes to tailor the contract to your particular needs. They, like any business, worry about churn from one provider to another, and they'd be more than, in my experience, happy to negotiate reasonable requests. I mentioned acceptable use policies, and you'll see that the usual things like content restrictions and prohibitions on use of broadcast email, so on and so forth. One of the issues around AUPs is that if they're not drafted appropriately, they can allow a backdoor way to get out of liability by the provider. So have a close look at those the acceptable use policies when looking at the contracts that you are negotiating. And the same applies for these liability caps, exclusions and disclaimers. As Emily said at the outset, providers will try and limit their liability as far as they can legally. You should make sure that the caps or the exclusions in the agreement are not going to leave your business, if you are general counsel of a business, for example, exposed. And a provider may be prepared, for example, to accept liability for negligence or gross misconduct or specific breaches, but maybe not everything. So examples of that might be a breach of specific security commitments that you require them to give you. That may lead to a breach of confidentiality, for example, or third-party IP infringement, where the cloud provider might be solely responsible. Transition in and transition out. This is an interesting item to deal with under the contract, and I say that from the point of view that it's not a one-size-fits-all. In fact, cloud contracts are not one-size-fits-all arrangement, but it's, yeah, some providers will transition you in free of charge for obvious reasons, but then they'll have some hefty transition out costs, and that's to do with getting your data in and helping you get into their cloud, and then of course getting you out of their cloud. So you need to make sure that you're right across the costs of doing that, and the businesses across the costs of doing that, and maybe negotiate in some set fees if they're going to charge you some fees. Or if you can negotiate an increase, for example, in the service costs that they might throw the transition in and out costs for nothing. My recommendation is if you can negotiate a set fee where the scope is wide enough to allow you to rely on that set fee, that's usually the best way to go. But critically, of course, is that the data that you pull out of their cloud is going to have to be useful to you if you're going elsewhere. So make sure the contract provides that the data, when it comes out to you at the other end, will be in some kind of useful form. And service level agreements, as I was saying earlier, this is where a lot of the devil lay in the detail. Work with your technical people, work with your CIO, to make sure that those service level agreements are appropriate for your business. Things like they have to be meaningful. That's what they have to be. If they're not meaningful to the business, then there's no point in having them, quite frankly. Having a look at things like, are we going to get service credits if, for example, they breach the uptime SLA? If there's a disruption to the services, things that should be looked at very closely and carefully, and we'll see on the next slide. Did I bring that down? Yes, I did. As I was saying, they've got to be meaningful. So if the SLA is vague and your technical team say, "Oh, I don't quite know what this really means," then you've got a problem unless you get some clarity around what the SLA provides. If, for example, they're going to offer you a limited scope of acceptance testing, then that's something that might not be appropriate. And the criteria around acceptance testing and the procedures really should be clearly defined so that your team knows precisely what they can do if they have to test some new software, for example, or changes that are made to the services. One of the important things is to make sure that there is an audit right. Now, sometimes if you are a particular business in financial services, whatever, you might have to have that audit right in the contract for your compliance regime. But I would say that every business should have a right to audit at least once a year if they have to. And then on top of that, once they discover in the audit some problems, a right to have those defects corrected within a particular time period, and I'd suggest at no cost. And just furthermore on service level agreements, you'll also need to look out for warranty periods. So if they're offered, for example, 30 days after acceptance of a particular software change, then you need to make sure that that period is sufficient. You can think of it almost like I made the reference to building a house. completing the building, and you have a certain warranty period to have defects corrected. They're done free of charge, just like they are done under cloud contracts. You don't want to find yourself at a position whereby you slip outside that warranty period and all of a sudden it becomes a cost to the business to have those things fixed. Okay, and again, things around service levels. Look, I should mention at this point in time, force majeure is one of those things that has come into sharp focus since COVID has arrived. Excuse me. And historically, I would say most lawyers have sort of looked at the force majeure clause in any contract, said, "Oh, well, that looks appropriate." But in cloud contracts, I think force majeure has always been something that had to be looked at very closely, considering that the service that you are buying may support the entire business. And if there is a force majeure event and the cloud provider doesn't have to perform their end of the bargain, you're going to be in a world of hurt, I'd suggest. So if you keep an eye out for the definition of force majeure, make sure that it's not going to be too wide or too loose, or going to put you at peril in the event that, or not so much put you at peril, but certainly cause you difficulty when it shouldn't. Have a look at that. Years ago, I had a force majeure event that included sonic boom. It was for a data center, and what was ironic about that situation is that data centers are meant to withstand certain crises, I'd say, and events, and they're taking control of the customer's data. I just thought it was quite unusual to have that in the force majeure clause. And so, still on service level agreements, service credits, said a couple of slides ago, if the service level agreement or what you're going to get is not meaningful to you, it's not going to make any difference as to whether you have it or whether you don't, then that's a pretty good litmus test to tell you that it's not going to work. So scrutinise what you're going to get in the event that a service level is not met, be it credits or be it payable as cash, whether it's going to be payable at the expiry or during the term or credited back against your next month's fees. Have a look at all of that, and it is flexible, or you can be flexible enough to cut that any which way you can within reason. So look, they're the main points, and I understand everyone's going to get a copy of these slides. So it's a nice little, each of those slides, it's a nice little summary of what to expect and what to request. And certainly if you need any further input or help, we're always here to do that. So Emily, back over to you for the duration.
Great, thank you, Brendon. So now I'm going to walk you through some practical tips your organisation should consider implementing prior to engaging with cloud software. As with any significant contract, due diligence before entering into a cloud services contract is a must. In particular, companies should identify the players in the cloud relationship and consider who will be involved in providing the service and who will actually be processing and storing your data. This may raise contractual issues relating to enforceability when services are unavailable or security is breached. When reviewing the terms of use in a cloud computing agreement, it is important to consider all the parties that will have access to or a relationship with the cloud, in addition to the contracting parties. It is important to consider their roles, rights and obligations, and whether each party has the rights required from the other parties in the cloud stack. Although the terms of the agreement may be non-negotiable, in many circumstances, companies should still consider the capabilities and liabilities of all parties within that cloud stack. When choosing a cloud provider, companies should consider the policies in relation to the data backup and recovery, and what will happen to the data upon termination or insolvency of the vendor, and the procedures in the event of a security breach or loss of service. This should be assessed against your organisation's specific data and privacy obligations, particularly if the data you choose to upload to the cloud is considered to be sensitive in nature. Companies should also conduct an audit of the history of the cloud provider to ascertain the actual service levels and the internet availability. The ongoing ability to provide cloud services should also be considered as well. Private and government organisations that utilise a shared private cloud or community cloud should also be aware that even if the data centre used is located within the local jurisdiction, it may be that the private organisation is owned or operated by a foreign company. This could mean that a foreign government could gain access to the data as the subsidiary server may be within the control of the parent company. Accordingly, government organisations must conduct adequate due diligence to investigate the organisations within the shared cloud and the prospective cloud service provider.
Now, if we just add to what Em just said there, I mean, doing proper DD is absolutely necessary. You don't have to put all your data out. You can choose certain parts of the data or certain services that you want to put out there in the cloud. Maybe not mission critical data and services. It depends on what each business wants to do. But ensuring that you understand that process, you understand what's going to go out there. You can slice and dice it any way you like once you understand that.
Great, thanks, Brendon. So some more practical tips include considering local backups as part of your data recovery plan, maximising access and use controls, configuring security and other settings to make it difficult for third parties to access your data without authorization, considering who in your organisation requires access to the data, and drafting appropriate policies to deal with cloud-based services or cloud-based software. And finally, considering whether it is necessary to store all information in the cloud, and if not all information, then determining which data is stored in the cloud, just as Brendon said. So organisations may find it helpful to rely on previous audits or certifications undertaken or obtained by cloud vendors. Organisations may need to rely on third-party audits and certifications, for example, ISO 27001 compliance. Organisations should also ask to review a copy of the statement of applicability, a copy of the latest external auditor's report, and the results of recent internal audits. Further, customers should also consider whether users access and store sensitive data only via trusted operating environments, whether the provider uses endorsed physical security products and services and devices, whether the provider's procurement process for software and hardware is trustworthy, whether the provider performs appropriate personnel vetting and employment checks for its staff, whether the actions performed by the vendor's employees are logged and reviewed frequently, whether visitors to the vendor's data centres are positively identified and escorted, whether vendor data centres have adequate management practices to identify tampering, and whether vendor security considerations apply equally to the vendor subcontractors. Finally, organisations should also consider the vendor's response time. So this is touching on what Brendon said earlier, in alerting its customers of potential attacks, and whether this response is adequate to enable your organisation to discharge its privacy and personal information and legal obligations. So this concludes the formal part of our presentation. Thank you so much for holding on with us, particularly at 4 o'clock on a Friday afternoon. We do have time for some questions, so if there's anything you would like to ask Brendon and I to cover, please submit your questions in the chat box. I do understand that we have some questions that have already been submitted. Okay.
Okay. Is it really realistic to expect the provider to allow the customer to control data breach response if the breach applies across the platform to all customers? I think the answer to that is you've got to arrive at a solution that works for both parties. It's obviously, if there's a cross-platform breach, then that's something that is going to be difficult for everyone to deal with. But the customer should really be across what the provider is going to do in that circumstance and assess whether or not that will work for the customer at their end. So the next question here is, if analytics are done on the data in the platform, it might not be possible to agree with one customer that the analytics won't run on a particular customer's data. Surely, provided the results are aggregated and anonymised, that should address the customer concerns. Yeah, look, I'll take that as a statement. I think that's probably right. However, you know, in terms of what we're doing here during this seminar, I think that's probably a little bit outside the scope. I'm happy to have a chat offline if you'd like to have a chat about that particular, but as a general comment, I'd say, yeah, that's probably about right. On liability, what is material, what is market? Wouldn't it be prudent to get your own cyber insurance to cover you? So, yeah, well, that's an excellent point. Cyber insurance is very important to have. They'll do things like, if in particular, some insurers will allow you to effectively get a data breach coach, if I can put it that way, involved and have pre-approved expenses for that data breach coach to step in as soon as a data breach is identified. As we all know, insurance and making claims and the like takes time. Time is against you when there's a data breach. You need to act very, very quickly. So if you do get in a situation where you are putting your service out in the cloud, I would highly recommend talking to insurers, depending on who you're with and what you want covered. It can be quite expensive, and in other cases, it might not necessarily be so expensive. But I can highly recommend that as a proper course. Let's scroll down here. Oh, it's the same question, I think. Is that right? Oh, no, hang on. Surely having every customer conduct an audit is not reasonable. It could cause confidentiality risk for other customers and impact performance. It's not the industry standard to require the vendor to have a third party do audit annually and provide report to customers rather than every customer individually audit. Well, look, that might be the case in some instances, but whenever I act for both sides of the equation. I act for providers and I also act for customers. It's not unheard of to have customers request the ability to audit at some point in time. That's been my experience, at least, acting on both sides of the fence. But I take the point that, you know, it can be quite cumbersome for a provider to agree to that. But nevertheless, if you're a customer, I would ask for it and see how you go.
And it might be the case that for certain standard quality and certifications that the organisation already, you know, embraces that concept and undertakes an annual audit anyway.
Yeah.
So if that's the case, why not have a crack at asking for, you know, the report that's produced as part of that process? It's definitely up for grabs. They might not agree to it, but it's definitely something that you could request.
And it might also depend on you know, if you've got a particular compliance matter that you have to have an audit, that you just simply say to the provider, we need this, we need it to comply with our obligations. So look, I think that's all.
We've got the liability
questions. I know we dealt with that one.
Oh, yep.
So look, I want to thank everyone. We've reached time or breached time. It's ironic that we're presenting this over Zoom, a cloud service, but I hope everyone enjoyed today's CLE. All the sessions are quite interesting and useful, in my opinion. And certainly, if there's anything that we can assist with from time to time, please feel free to contact us. Our contact details are available there on the screen. So have a great weekend, and thanks everyone once again.